best to navigate the world of estate planning and legacy and what have you. And so my encounters with my good sister, Sonia attorney, Sonia Tansley, led to this time and place. We were just talking about it, and she said, "Yeah, I'll do it." And so she was faithful enough to inquire further as to what time are we thinking. So I had to come down on some dates. And so once that was done, she committed to that and decided, okay, I'm going to come and do this. So we are thankful. She's a seasoned attorney and one who has availed herself, especially to our folk who don't always do what she's going to share with us. So we are thankful and we welcome you to Westchester, and we trust that what you share is what God has prepared for us anyhow. So thank you so much.
You're welcome.
Yes.
Good morning. Good morning, everybody. My name is Sonia Tanksley. Everyone calls me Sonia, so if you have a comment or a question, just feel free to call me Sonia.
And she's a native New Yorker.
I'm a native New Yorker, but not New York
City.
I'm actually a native New York State person. I was born and raised in Albany. I came in this direction for college. I stayed for law school, and I've been here ever since. So I'm joining you today to talk about trust and estate matters. Lots of times our people just don't talk about it. We don't do it. We don't plan for anything in that area. And it's really important that we do, even if we don't think we have a lot of assets. We have something, right? Everybody has something. And what you'll also learn a little bit today is, even if you think you don't have much, we don't know what we'll pass away with. Because sometimes in death, we're entitled to certain things that we haven't planned on what we want to do with those assets, those resources. So I'll start by telling you a little bit about myself. I've been an attorney for 33 years. I practice in three main areas. That's trust and estates, real estate, and corporate transactions. And I also handle litigation in all of those areas. My office is in Dobbs Ferry, which is just a little ways up the road from here. But I practice in all of the boroughs except for Staten Island and Westchester County and a little bit here and there in Long Island. Not as much, just because that's the way it's worked out. I've prepared an outline that you can follow along with. The outline is really an outline of what I'm going to talk about. I prefer to make this a little bit more of a conversation instead of a lecture or a presentation, because I think you learn more when you just have the conversation. So if you have questions along the way, just somehow let me know. Raise your hand, stomp your feet, clap your hands, whatever you want to do. And if we get a little bit too off the tangent, I may have to kind of quiet the questions for a little bit. And if you can, please try not to make the questions too personal. Maybe think in your head about making a little bit more objective so that you're not unknowingly sharing more than you intended to share. And even if I recognize that it's a little too personal, I may ask you to contact me later, because I don't want to give legal advice on a personal issue to a big group. So let's first start talking about what we call advance directives. Advance directives is a big fancy word for saying, in advance, I'm going to direct folks on what I want them to do. One of the documents for that is a power of attorney. Does anybody have one already? You do? Okay. So power of attorney, you're familiar. What's your name, please? What? Victor? So Victor's already familiar with the power of attorney. A power of attorney is a document that allows somebody else to handle affairs for us And while they're handling those affairs, they will, of course, be making certain decisions. The idea is that you tell them what decisions you'd like them to make on your behalf, or you tell them how you want them to carry out your decisions. Once they have that power, it's a lot of power, right? So you want to really be careful who you give that kind of authority to. It's a very powerful tool. Somebody can have your authority to handle affairs on your behalf, and now you've set them free to walk about the earth, doing your tasks for you. So there's a lot of trust involved. The person who gives the power is called the principal, and the person who receives the power is called the agent. You can limit your power that you give them in the, hi, how are you? Please take one of the handouts. And the document has, the power of attorney itself can be limited, and you can say, I only want you to have the authority to go to the Social Security office on my behalf. Or you can give them broad authority to handle everything on your behalf. So it really depends on what the purpose is, and it really depends on whether you want it to be for the long term or just for one discrete task, because you'll be away on vacation and this task has to be taken care of. The power of attorney can be revoked. The tricky part is, if you've given them power of attorney to handle banking work for you, for example, they'll go to the bank, they'll bring that original power of attorney that you sign in front of a notary, they sign in front of a notary, as well as 2 witnesses. The bank takes that power of attorney, and depending on the bank, they may keep the original or they'll scan it in and they'll keep it in their records. So let's say they've gone to 3 of your banks, and then you say, I don't want you to have any power to do anything for me anymore. This is not working out. Or the task is done, I'm going to terminate this power of attorney. What it's really called is revoking the power. You have to go to all of those banks that they went to and give them the revocation. And you have to give the person the revocation. So as you can see, it's really important because they may have gone to Chase, Citibank, and Wells Fargo. And you only went back to Chase and Citibank and filed the revocation. You didn't go to Wells Fargo. So they can still interact with Wells Fargo. Now, I don't always like to assume that people have bad intentions. But maybe they thought that you still wanted them to handle things for you because something got lost in the conversation that you had with them. So it's important that there's communication. It's important that it's obviously someone you really trust to do only what you want them to do and only for the time period that you want them to handle your matters on your behalf. Sometimes it's indefinite. You always want this person to be able to handle your affairs. Maybe it's a spouse, maybe, because not always it's not automatic that your spouse is able to handle your affairs for you. Maybe it's your son or your daughter or your sibling. But don't take it lightly. Victor, you probably didn't take yours very lightly, right? Yeah, it's because they're standing in your shoes and they're able to do as you would do. Good morning. Good morning. The next advanced directive is a healthcare. Oh yes, I like questions. Go ahead.
I just have several questions about it.
You're in the back, so speak up so everybody can hear you.
Sure. Does the power of attorney ever expire?
It does not expire. There are some instances where someone will take the power of attorney, your agent, to an entity, and they'll say, oh, you did this back in 2019. We want to make sure that you still have authority to act on Victor's behalf. So they may want an updated power of attorney, or they may want you to do an affidavit saying, yes, the power of attorney is still in full force and effect. But in general, it does not expire.
So if it doesn't expire, why would they want an amendment?
Because they want to make sure that there wasn't a revocation that they weren't made aware of. Yes?
Is it typical for organizations to ask you to do their own power of attorney,
Yes.
even though you have?
Absolutely. Some organizations, some banks, some government offices, like the IRS, they want you to do their own power of attorney, as well as some banks. That's that's just their policy, and you're forced to do it in order to have someone act on your behalf with them.
And then my last question
Mhm.
about this. How do we as lay individuals learn more about the power of attorney so that when it needs to be enforced or used, we're not duped? Can't think of the right word right
Duped
now.
is a good word. We all know what duped means. Be careful with the internet, right? And I say be careful. The internet is a powerful piece of information, or has powerful pieces of information. The challenge with the internet is its interpretation and its application on what you're trying to do. So you can get some information from the internet. You also don't know if it's applicable in the state or in the county where you're trying to handle the matter. So that's one resource. The only other resource, honestly, is with an attorney. We're going to be the broadest resource for what the more finer do's and don'ts are with a power of attorney. And another thing is, a power of attorney in New York is not necessarily valid in another state. New York State loves to be very finicky about its forms and its documents that are accepted. So certainly powers of attorney from another state are often not accepted here in New York State. New York State has its own format that it wants people to follow. And one of those is having two witnesses. So every now and then, it doesn't happen often. I've been practicing law for 33 years. So once in those 33 years, New York State updated the power of attorney form that it will accept. The biggest change on that update was that you have to have two witnesses sign the power of attorney. And that's really for the protection of the principal, the person that's given the authority, because you don't want me I'll always use me as the example. You don't want me going to someone who may not fully understand what they're doing, saying, "Hey, I'll take care of your affairs for you. You just have to sign this power of attorney." You want two other people to be there to witness it and make sure that the person isn't being manipulated. So that's not always foolproof, but that's New York State's version of, let's try to make it a little bit more secure for the person who's handing over their authority. You're welcome. Any other questions on the power of attorney? Yes?
What about if it's drawn up in another country? Is it valid wherever you go?
It's not necessarily. If it meets all the requirements for whatever jurisdiction you're trying to use it in, then it can be valid. So for example, if it has, for it to be valid in New York State, if it has if the principal, if they are signing in front of a notary, if the agent is signing in front of a notary, and if there's two witnesses, it can still be valid here in New York State. But that notary piece is important because the notary in another country would have to be a notary that's accepted here. So for example, if folks go to the consulate and get a notary, then that would be accepted here. But if it's another more localized notary that's not accepted here, it would not be applicable. Yes?
If the agent abused the power given, what recourse does the principal?
You would have to sue them because although they're the agent and you've given them authority to act, you have not given them authority to do illegal actions like steal your money,
Right.
or sign to purchase things on your behalf with your credit. That goes beyond the scope. So you can sue them for, you can have the police department press charges for fraud or other illegal acts, and then you can also sue them in a civil lawsuit.
One more question. So
Sure.
let's say you have a power of attorney. Wouldn't that power of attorney be effective if you're incapacitated? Can you state that?
Yes.
Yeah.
You can state that in
That's
the power of
only
attorney.
time.
Yes.
Yeah.
As long as you did not sign it when you were mentally incapacitated. You can be physically incapacitated, but you're not. It's not valid if you did not have the mental capacity to understand what you were doing.
So what I'm trying to get to, so why, I mean, the agent should not be doing anything while, if you're not, like say you're ill or you really can't manage your business, your finances.
Now, are you talking about physical illness or
Anything at all. Like if you're incapacitated, that's when then you can be my power of attorney.
Mm-hmm. So the power of attorney, one of the reasons we sign them is if I get sick and I can't go out to the doctor, or I can't go out and handle my affairs because I'm just too sick to do it, then I want you to have my power of attorney to handle my affairs for me so that all of my affairs don't go down the drain while I'm sick and recovering from stomach surgery. But when you cannot use it is, well, you can't even enter into it, is if you did not have the mental capacity to give someone your authority. But you can say in the power of attorney that even if I become mentally incapacitated, this power of attorney remains in full force and effect. That's a bit of a gray area, though, that can be contested. So that's going down another road. Does that answer your question? Because you want it to be, that's why you're doing it. Well, that's one of the reasons why you're doing it. In case you may be going in for surgery and they're telling you that you won't be able to walk, you won't be able to leave the house, you won't be able to do lots of things for 6 or 8 weeks after surgery. So you may give someone a power of attorney to handle your affairs during that time.
So I guess it behoves us to really trust and choose someone who we can really, really, really trust. Right?
Yes. And sometimes what people do as checks and balances is they'll appoint 2 people to act in concert with each other as the agents. Yes, ma'am.
You may be aware, I think last week I saw it in the paper where a principal's relative could not reach her in New York State. And when she did, she found her in squatter.
Okay.
And on further probing, the other niece who had the power of attorney had taken out $2.3 million out of the account and left her in squabbles in Queens. And they won. They took it to court and they awarded the estate back that money.
Right.
Even though the agent was given the power of attorney, but she didn't act in good faith.
She didn't act in good faith. Right. You still have to act in good faith. You still have to act in the best interest of the principal who has given you the authority to act. You can't just it's not a license or authority to just run amok. Anyone else? So the next document that's very common is a healthcare proxy. The healthcare proxy is just what it sounds like. You sign something that says, if I'm not able to make medical decisions on my own, for my own best interest, I want my best friend, my sister, my parent, my sibling, whoever you trust with those medical decisions to make them on your behalf. You sign it. Again, you're going to sign that in front of witnesses. The healthcare proxy does not need a notary though, but you will sign it in front of witnesses. And that person has the full authority to say, you went in to get a mole removed on your arm and the surgeon comes back out and says, this is more than what we bargained for, we're going to have to take a portion of her arm off. You're trusting that person to make the best decision. So it also is a very big decision, very, very significant authority you're giving someone. You may also be giving someone the authority to impact your life with respect to making a decision to terminate life-sustaining equipment. Sometimes you give that, sometimes people who are married give that authority to someone else. And not always for bad reasons. Sometimes they just don't feel like their spouse is going to be in a position to make a decision if the circumstances turn that way. They think their spouse may be too emotional, and maybe their decision would be to do this, and their spouse would not follow those directives. So it's still another big decision to make. You generally leave that health proxy with your physician if you're admitted to the doctor, if you're admitted to the hospital. And you may all remember, if you've ever been admitted to the hospital, the social worker often comes around, or a nurse, and asks you to sign a healthcare proxy if you don't already have one. And then they keep it on file. Yeah. The next document is called a... Oh, yes. Mm-hmm.
DNR falls under that?
No, a DNR is different. A DNR, everybody knows it's do not resuscitate. A DNR is you're taking the decisions out of everybody's hands. You're just saying, if I'm unresponsive, do not resuscitate me. That's completely different from the healthcare proxy, because now you're not giving me the authority to make the decision. You've already made that one singular decision. And typically you'll post that in your house, on the refrigerator, by your bedside, lots of places, and you'll tell everybody too that that's your wish to not be resuscitated. And certainly if you are admitted to a hospital for any reason, if you want that to be the case, if you're unresponsive to not be resuscitated, then you let them know and they will have you sign a DNR. A living will. Living wills, sometimes people confuse them with a will. There's a big, big difference. A living will is just as it sounds, is you're saying what you want to happen while you are alive. So, if you are ever in a position where there's a choice to be made about giving you treatment that will sustain your life, despite the fact that medically they believe life is leaving you, the living will tells everybody exactly what you want. So when it's drafted, you can say things as specific as, do not give me nutrition, do not give me hydration. If I'm past the point of any reasonable expectation of recovery, only give me pain medicine. Or you can say, if I can't eat or drink orally, you may give me fluid intravenously, but do not give me any nutrition. You can get as specific as you want. You can also say on the other end, do everything possible. Keep me on life support as long as my insurance will pay for it, or as long as I can pay out of pocket. Don't ever turn that machine off. You can have that as your wish. There may come a point, depending on your personal circumstances, where you no longer have that option to just stay on artificial devices to be kept alive. But you can say, do it for as long as you can. My father wanted to be kept alive no matter what, and he says, my father's passed on now, I love him so much, but he says, do me like Walt Disney, put me in some liquid, and when they figure it out, bring me back. I don't know if they did that to Walt Disney. I never looked. He said they did, and that they're still waiting for the science to catch up with that ability. We didn't do that. I hope he's not upset with us, but yeah. So you can say anything you want, and to the extent it can be done, that's what you will have the folks who are left behind, your healthcare proxy, more specifically, to do. So they work in tandem. The living will has the directives of what you want in case you're in a medical state where there's no reasonable expectation of recovery. And then you have your healthcare proxy, which is the person who's going to carry out what your wishes are, as well as, if you haven't spoken to what your wishes are, what they believe you would want to happen. And it doesn't have to be a life or death situation. Sometimes it's, they go in for surgery and they're going to, operate on your kidneys, and they come out and they say, we're going to have to just remove one of the kidneys. They can certainly live without the other, or we can leave it and treat the person. And that proxy may say, no, if the kidney's bad, go ahead and remove it. And, it's often that these things are not such a surprise. It's been discussed a little bit, so you will have told your healthcare proxy some of the options of what you may want to happen if certain circumstances come up. But of course, there's those other instances where nobody knew what was on the horizon, so you're trusting your healthcare proxy to make decisions not only in your best interest, but hopefully in alignment with what you would want also. The next advanced directive is the general will. And we say these advanced directives because you're directing what you want, right? Some of these directions are what you want while you're alive, and then the will, of course, you're saying while you're alive what you want to happen after you pass on. So remember, the big difference between the living will is what you want to happen while you're still alive, but in the event you're deemed so sick and so ill that there's not a likelihood that you will survive. And then the will just says, after I'm gone, this is how I want my assets distributed. The purpose is to ensure that the people that we want to have certain things receive certain things, our assets, our resources, and on the other side to make sure that people that we may not want to have anything, we don't let them have it, right? So when we pass on without a will, it's called passing on under New York State intestacy laws. So what did I put in my example? I think I put an example. Maybe not on yours, but on my notes. Let's see if I gave an example. Yes, if a woman is a widow, meaning her husband has already passed on before her, and she has 3 children. If she passes away without a will, all of her assets will go to her 3 children equally. If she has a will, she can change that. She can direct that all of her assets, for example, go to her grandchildren, and that her children don't receive anything. So you can make decisions in any way you want with respect to almost any way. You have a broad parameters on what you can do with the will. There's certain things that you can't do, but we won't necessarily go into those examples today. And you can also designate a guardian over your minor children within a will, which is really important because, let's say husbands and wives, they may talk about if both of them pass on, heaven forbid they're together and they both pass on, or they pass on separately, who would they want to continue raising their children? And that's something you would outline in your will. The components of the will. So there's a couple of main components. One is the beneficiary. The beneficiary or beneficiaries are the people that are going to receive your assets. And you can have as many beneficiaries as you want, or you can just have one. But it's the time that you have in this document to indicate who's going to get what, right? You can give assets to a nonprofit. You can give assets to your church. You can give assets to a community organization. You can give assets to the care of your pet if you want, and they're set aside. So, and I've really had it. I've had people who decide they're going to give all of their funds. There's these organizations that you can give your funds to, your resources, your assets, and they will be responsible for taking care of your pet. So these folks had a lot of resources, and they wanted this organization. They had feral cats, which are the cats that just live outside in their backyard. They had feral cats and they had indoor cats. So they were leaving, they didn't have children, they were leaving all of their assets to this organization who will take care of the house and to take care of the cats for as long as the cats live. And thankfully all the cats were fixed, including the feral cats, so this was all going to come to an end at some point. And then they had plans for who the remaining assets would go to. But yeah, yes ma'am.
But Leila Emsley did that, and the court reversed it. Why did the court do such a thing?
This is Helmsley. To remind me what she did, right?
She left assets to her cats,
Mm-hmm.
and one granddaughter. She excluded the other ones.
Mm-hmm.
So they took it to court, and the judge reversed her will.
The other children who were left out of the estate took her to court. I don't remember why, they could have proven that that will was done under. There's ways to challenge a will. The will was done under duress. That will wasn't signed effectively, meaning two witnesses, a notary.
No, that wasn't the case.
I don't know why they reversed it. I don't remember that. I remember the case, and I remember she left, and I think it was the other children who were completely left out of the
The will,
estate,
yeah.
contested the estate. I'm not sure. I don't remember why though. That's something good for me to look up to see why the court reversed it.
So how successful can one who's left out of the will? Like you said, you have 3 kids. You can determine who's gonna get what,
Mm-hmm.
and you may decide to leave John out.
Mm-hmm.
I've heard that you have to mention. Is it true that you have to say, "I'm gonna give $1 to John"?
You don't have to. The reason we as practitioners, attorneys do that is to make it clear that yes, I thought about you.
Right.
I didn't forget. and I'm intentionally leaving you out, and here, take this $1. Not I want you to just only have $1, but I'm intentionally mentioning you to the extent where you are not going to receive any assets. This was not an error.
Oh.
So when you say how successful someone can be in contesting a will, there's lots of ways you can contest a will. You can prove that the person didn't have mental capacity when they signed. You can prove that they were pressured into signing it. You can, if it wasn't done under the proper circumstances, meaning there were 2 witnesses, the will, the specifics of the will are not read when we do a will signing, but there's certain language that you have to say, like, is this your will? Have you had a chance to review it?
Mm-hmm.
Are these your intentions? And then these 2 witnesses are there hearing all of that. Mm-hmm. And if the attorney doesn't go through all of that to confirm your capacity, to confirm that you know what you're doing, I'll ask questions like, what's today? Who is the president? Who's the mayor of New York City? Where are we? Why did we come here today? Did you have any medicine that alters your ability to understand? Some people have told me when I say, did you have any food or alcoholic beverages before you came? Oh, yeah, we were doing shots before we came. I said, okay, well, we can't sign today. Well, I only had 3, and it was over lunch, and I ate food with it. Well, I can't sign the will because I don't know what your capacity is for drinking 3 shots, right? So then I won't do it. And they'll say, no, I was just kidding. And I just you know. But, when they came in, I smelled the alcohol, so I knew that they were drinking, but they want to really go forward with the signing that day. So there's certain recitations you have to go through, and you'd be surprised how many practitioners, attorneys, just don't, because they think, what's the chances of this being contested? Or there's times where I've been called to Calvary Hospital to have someone sign their will. And that's always tricky because they're not in their right state of mind. They are under duress. Sometimes when they're really insistent, if they have 3 kids and 4 grandchildren, I'll say, okay, everybody's got to be there. Everybody has to be there. I try to think of all the people that could possibly contest. Because sometimes, just because you're in end stages of life doesn't mean you still don't have mental capacity. But someone still could claim that we did it under duress. So you just try to put all of the safeguards in place. And because I do litigation, I know what the lawsuits look like and what the challenges are. So I just try to put safeguards in place to minimize the risk of this will being challenged. Yes, sir.
If you have that problem, could you have a representation for the individual?
Say that question again. I don't quite understand.
If you had the example just gave,
Mm-hmm.
can you have a representative for the individual?
If someone wants to, you mean the situation where someone wants to contest the will?
No, someone who you think does he have the capacity on his own or on her own to let you sign or let it?
Well, if I'm the attorney that's doing the signing, then I'm their representative, right? So it's up to me to really, although I'm not a clinician, we attorneys do still have a responsibility to make a reasonable evaluation of whether we believe the person has capacity to sign the will. So that's why I go through, and we're all supposed to go through all of that recitation of questions. What's your full name? What's your date of birth? Who are these people here with us? Who am I? Why did you call me here? Who's the president? What did you have for breakfast today? Asking them basic questions to see if they just have basic knowledge, and just have a reasonable understanding based on my relationship with that person and the attorney-client relationship of whether I think that they have capacity to sign this document today. And sometimes it's really very clear, like, you can't sign this today. It's not a hard test to fail, I'll say that.
To protect yourself, do you record those responses?
I don't record.
how will you
I
record?
have the two witnesses that are there, right? And then I'll also have someone from my office staff present.
Okay.
Can it be videotaped for the process? So in
The
case it
process
comes
can
up later.
be videotaped. I've never had anyone ask me to videotape it. I would have to look at. I'm always going back to look at case law to see what that looks like, because it is a very private affair. So then, what are we doing with the videotape after
In
we?
case it comes up later on to challenge.
Oh, you mean
challenge you.
videotape for my purposes? Oh, yes. I rely on the witnesses and my office, someone from, either my associate attorney or I have a paralegal. One of those two people will be present. Let's see. Any other questions about the will? So let's talk about, we talked about the beneficiary. The other person that's a key component in the will is the executor. The executor is the person that you name who will facilitate what you want to happen in the will. So after you pass on, that person will most likely take that will to an attorney and have the will, what we call, probated. So the probate process happens in surrogate court. The will gets presented to the court. It gets filed. The attorney will prepare a whole cadre of documents, including a petition and waivers and affidavits, and all of that gets filed with the court in order to have the executor appointed by the court. So even though you name your sister as the executor in the will, the court still has to vet them out to a certain extent. It's not a vetting like they have to give their social security number or do a background check, but it's a vetting to the extent of just who is this person that's being appointed? Do the other people named in the will have any objection to this person being appointed? They have a right to object. The objections have to be pretty substantive, not just you don't get along with them, you haven't, it's your sister and you haven't been speaking to your sister for the last 5 years. You would have to really prove that this person doesn't have, they're not fit for duty, let's say that. So let's say you happen to know that they have filed bankruptcy a couple of times in the last few years. Let's say you know that they have been convicted of fraud at least once in the recent past. Let's say you know that they were fired from their job as a bank teller in the recent past. You can bring up all of those things to say, and therefore I don't think that this person should be handling my brother's will. Go ahead.
Even though I already chose this person to be.
Even though you already chose this person because maybe you didn't know, maybe you didn't realize the full extent of what their responsibilities were going to be. And the court just wants to make sure, once that person's appointed, they're really, really going to do the right thing, because now they're in charge. They're going to be charged with the responsibility and given the authority of going to all of your banking institutions, collecting the money, putting them in an estate account, selling your house, getting the money, putting them into the estate account, and then distributing that money according to the will. there are unfortunately lots of cases where a person is charged with that responsibility and steals the money.
So what happened in that case when the executor is removed?
Well, if you have a will that I do, there's an alternate executor named in the will. So the alternate will step in. And provided there's no objections to the alternate, there's no objections that the court agrees with, the alternate will step in as the executor.
Because the probate is only done after the person dies.
Correct.
Principle.
Mm-hmm.
So when somebody goes online and print a will form and say, I'm doing my will, I don't need a lawyer.
Mm-hmm.
Is there value in doing that?
Well, I can't say there's no value in it. The challenge is making sure that it's executed properly in a way that cannot be easily challenged. When you go on the internet, sometimes those documents aren't valid for the state that you live in. They're often generalized documents, but sometimes you'll do a search, and so, especially now after we've had this talk, New York State will sample, right?
Mm-hmm.
Go ahead.
Is a revocable living trust better? I know it's more expensive.
That's coming up next. Yes.
Okay.
If you turn the page,
Yes.
that's it.
I'm always hearing that that's the best way
Yes.
to do it, although it's expensive.
So it's and we're gonna get to that in 1 second. Thank you. So there can be value if you know what you're doing. Yeah. If you don't, you just potentially wasted your time. Yeah. When the will.
This legal service.
Uh-huh.
While you're living, if you make it in your will, it's time for the reader will, and somebody comes from somewhere, or one of the members of the family say, this person's not supposed to be there. Is it, what do you do with that?
Say that last part again. You prepare the
I'm
will.
living it, if I prepare my will,
Uh-huh.
whatever happens if I die and somebody open my will, everything that in there, nobody can contest it?
No, people can contest the whole will. But
I was living when I did it.
Yes. So just because I raise an argument against the will doesn't mean I win. Contesting a will is not easy. It's not easy, and it's also very expensive. It is I've said it kind of succinctly, like this is what happens, but it's a long process, right? You can do it by yourself without hiring an attorney, but that makes it more difficult because there's a high standard that you have to meet in order to say someone's will is not valid. Because in general, the court really wants to take these wills and let your executor do as what you said because you were alive when you did it, and this is what I want, right?
Like you said.
I like that. But so someone can always contest it, just like someone can always sue you. I can sue you and say you stole my coat, right? We were at this session and you stole my coat. That doesn't mean that I'm going to win. You never touched my coat. You don't know what my coat looks like. You could not spot my coat. If someone threw it over your head, you wouldn't know if it was my coat. But I can sue you for that. Now, ultimately, it's going to get thrown out, and then you can sue me back for bringing a frivolous action, things like that. So it's the same thing with the will. Someone can attempt to contest the will. It doesn't mean they're going to win. The test is very high to win contesting the will. The court will presume that everything was done properly and that you knew what you were doing when you did it. So, me contesting the will, I have a high test to prove that something was wrong. It's not easy to overcome that. So let's talk about if you do not have a will. There's a huge benefit of doing the will. If you don't have a will, this is this is I tell little scary stories if you don't have a will. So, I'm married to a lovely husband. I pass on, and I have a lovely husband and a lovely child. I pass on, and I don't have a will. Part of my assets go to my lovely husband, and part go to my lovely child. My husband mourns appropriately. He doesn't do a will either. He mourns appropriately for a long time. Only wears black because he's in mourning, right? Then, years from now, people say, it's time for you to remarry. They fix him up with another lovely woman. Not as lovely as me, but lovely nonetheless. Right. And all of my riches, my $10 million that went to him and my lovely son, didn't have a will, right? He marries, and then tragically, and it's not an even split, but let's just say he has $5 million. And he doesn't spend money, right? He doesn't. He shops at Marshall's, he drives a Prius, he is very, very conservative, right? So, Marshall's is my favorite store, and TJ Maxx too. They run neck and neck for me.
Yeah.
So, tragically, right after he marries this lovely woman, not as lovely as me, he passes away.
No will.
No will.
Who's money?
And she was helping him raise our lovely child.
Oh, yes.
And so that money stays in a custodial account for our lovely child until that child's 18 or whatever. So, somebody else will start managing that money. But she gets like $5 million. She's lovely and all, but that's not what I wanted.
You don't know
right?
her.
I know. And now she's going to go on and marry some other slightly less lovely man. And now they're going to be living on my $5 million. And that's just not what I wanted. They're lovely and all, but that's not what I would have wanted. And if you don't have a will, things like that, that's an extreme case, but that happens. It really, really does happen. But you don't really have much control over what's to be with your assets. Whereas if you do a will, you know exactly who's going to get your assets, and you will have contingent beneficiaries. So you may say, this is going to my sister, and if she predeceases me, I want it to go to her daughter. And so on and so on. So that's why it really is important to set out what you want to happen. There are instances, some may say, I don't have a house, I really don't have much money. What's the point of all of this? Well, there's other tragic stories I could tell you that make it purposeful. One is that you don't know the circumstances in which you will pass on. Sometimes you may pass on as a result of a terrible accident, and so your estate is entitled to significant resources after you pass on because your family sues the MTA because you had a terrible accident that resulted in your death, and MTA was the cause of that accident. So you want to be able to say what's going to happen to those assets as well. You may not have anything right now, but in a couple of years from now, because life changed and things became more bountiful for you in various ways, and you now pass on, and you didn't say what was to happen with what you have. Or there might just be sentimental items. There might be a quilt that you want to make sure goes to this person. There might be, there may be some important artwork to you. It may not be worth a lot at an auction, but it's important to you, and you want to make sure certain people have those items. So it's always important to do it. It doesn't have to be a super expensive process to do just a simple will. But it's important to lay out what your legacy with respect to your assets or the things that are important to you, what will happen to them. And you know what? This part doesn't benefit you, but it helps those who are left behind. I think it warms our heart a little bit to say, oh, Auntie wanted me to have that necklace. I always wanted that necklace. It may not be worth a whole lot of money, but it was important that I left that necklace to my niece because she always admired it, and I thought about her before I passed away to say, yes, you're going to be the one to have this necklace. So a trust. As you see from my little cartoon character, a trust is a tricky thing. The trust that I'm going to talk about today, there's two main trusts that I'll talk about. There's a trust is like a grocery list. I could be here until next week telling you about all the different kinds of trusts that there are. It's two main types are the revocable trust and an irrevocable trust. Does anybody need a pen or scrap paper to write notes? No? Okay. So a revocable trust, the purpose is to transfer assets after death. That's one of the main purposes, right? You put the, this is actually my brother's doctor who's very sick, and I'm just going to let them know that I will. Hello. Okay, so a revocable trust. One of the main purposes is to transfer assets after you pass on. The benefits of a revocable trust are there's no probate. So with a will, I'll step back for a second. Your executor's going to go to an attorney. They're going to pay a lot of legal fees, depending on the size of the estate. Most of the time, the legal fees are commensurate with the value of the estate. You're going to pay filing fees to the court, and there may be a bit of a long process. Bronx surrogate court, if you all live in the Bronx, Bronx surrogate court is taking like 4 to 6 months to have someone appointed as the executor. So it takes a while before you can actually even do anything. All those assets are just sitting there. With a trust, there's no probate. You easily transfer the assets after the person passes away, whether it's cash or stocks or bonds or even real estate. And you get to still manage all of your money. So let me make it a little more practical for you. So you may have a house and you may have $1 million in the bank. If you transfer that to the ABC trust and you are still the trustee, right? And then you name your best friend as the alternate trustee. So you're still managing your house, the mortgage, all of the bills related to the house, and your money that was in the bank account, just as you do right now, every single day. It's just that the trust, the house, the deed for the house now says the ABC Trust, and the bank account says the ABC Trust. But you are the trustee, and it's really still all of your money, because it's a revocable trust, and at any time you can revoke it, amend it, change it in any way you want, right? What happens is you will name an alternate trustee, so that after you pass on, that alternate trustee will carry out the directives in the trust. You will also have, this is the key part, beneficiaries of the trust. So you may say in your trust, the language may indicate that when you pass on, the house is to be sold and the $1 million is to be divided amongst your 2 children. You can also indicate that, geez, my phone doesn't ring this much ever. It really doesn't. It's always quiet. And also, if you become incapacitated, you can name somebody else to manage your trust for you while you're alive. So the big difference is, if you have a trust, when you die, what's going to happen? That trustee is just going to, without any court involvement at all, they're just going to sell the house, take the $1 million, and in my example, split the $1 million between your 2 children. They're going to take the money that was in the bank, because remember, it's in the trust, and they're the alternate trustee. So they're just going to write the check for that $1 million, $500,000 to this child, $500,000 to that child. That's it. It's done. They can write that check for that trust for the funds that are in that trust bank account the day after you pass on. It's, there might be a little bit of document exchange with the bank, but it's not like you're sitting waiting for the court to appoint somebody. Yes, ma'am?
So there's no lawyer involved if you have a living trust.
If you have a revocable living trust now, you don't have to. Lots of people still do because they want to make sure that they're doing everything properly. But the legal fees are nothing compared to the legal fees related to probating a will. And the way the lawyer gets involved also is if you, like, let's say there's a house to be sold, you'll retain the lawyer for the closing. But in terms of distributing the assets that are in the trust bank account, you don't need a lawyer for that because you're the alternate trustee.
So the lawyer helps you to create this trust and then after that.
Right. So in terms of, you know, and I like to be very, very real with this stuff. In terms of legal fees, you'll pay the legal fee up front to have the trust prepared, but it's a lot less than what your family is going to pay to probate that estate. It's a lot less. And I think well worth it, right?
A quick question. Is the executor or the alternate trustee, is that a paid position?
So you're saying lots of things. So the executor, under a will, it doesn't have to be a paid position, but under the statute, the executor is entitled to a commission.
Okay.
And the commission is based on the value of the estate, and it's a graduated payment scale. So it I don't know it by heart, but let's say it starts at 5% of the total value of the estate. A 5% maybe for the first 100,000, and then 3% for the next 200,000. The percentage goes down as the estate value goes up, right? But it still amounts to, you know, because it's actually a lot of work.
Yeah.
Being an executor is not, even though you're doing everything in concert with the attorney, you're doing a lot of legwork. I'm telling you, okay, do this. Okay, I need you to gather this. Did you get me this document? All right, I'm going to send you this document. I need you to sign it or in front of a notary and bring it back, or you can come to my office and sign it and I'll notarize it. It's every week we're talking and you have a task list to do. Or you can turn it all over to me or whatever attorney, but people generally only do that when it's a very large estate because that's all billable hours for an attorney. And sometimes when it's a relatively modest estate, you don't want all of the money getting eaten up by the attorney. So then I'm sending you out to the world to do all of the legwork. And that's a lot less expense on the estate. But sometimes when it's just a big, huge estate, there's lots of assets, there's stocks, there's lots of properties, there's this and that, the executor just says, just do it. Just do it and send me the documents to sign. So back to the trust. You'll pay the legal fee up front to have the trust prepared and facilitate transferring real estate into the trust because it's a little bit tricky for a lay person to do. But with respect to the financial assets, you do that yourself. You take the trust, you take the tax ID number that I will get for you or any attorney will get for you for the trust, and you go to the bank or whatever financial institution and you tell them to open up a new account in the name of the ABC Trust. And then you, with a revocable trust, you are the trustee. You're still managing everything as you do right now today. And you can always end it. You can say for whatever, you know, there's lots of reasons why people terminate their trust. You can just terminate the trust by transferring that deed back into your name personally. Or just take those funds, write a check, and write a check to yourself personally, and put those funds right back into your personal name. There's some really important reasons why people do that, but most of the time they do
some of those reasons, like maybe two,
Oh.
just to get an idea.
Sometimes it has to do with tax reasons. Sometimes it has to do with divorce. Sometimes people did nifty things thinking that they were trying to hide their money for litigation purposes, and the court orders them to put it back into their name. Those reasons.
Thank you.
Yeah.
Can you do that trust, when you do this trust, are you, would you be married to do that or do it as an individual?
So if you're married,
Yeah.
you do your trust separately. You would both have separate trusts. You can do a joint family trust, where you're both combining all of your assets and putting it into one trust. You can do it either way, and that really depends on some other more complex estate planning that you're doing.
Let's say you're living by yourself, not married.
You're not married.
Who will verify that trust for you?
Who will verify it? There's no verification necessary. You will have, while you're alive, you're the trustee, and then you will also have named an alternate trustee who will take over when you pass on, and that person will step in and distribute the trust assets as you indicated in the trust. Okay? Irrevocable trust.
Excuse me,
Yes.
you didn't answer the second part
Oh,
of
I'm
my
sorry.
question.
Mhm.
And does the alternate trustee get paid? You didn't answer that part.
The attorney, you're saying attorney trustee.
The alternate trustee. She had asked you.
Oh, the alternate
Yeah.
trustee, I'm sorry, very sorry. So the trustee, once the alternate steps in, they are also entitled to a commission. And that commission is based on that same statutory graduated scale. So, yes. They're entitled to it. They don't always take it, but they are entitled.
They don't always take it?
They don't always take it. Sometimes people, particularly when it's a close family member and all of the assets are being given to, like the children of the original trustee, they'll just say, it's okay, this is just what I'm doing to make sure that the kids are okay. But they are entitled, yes. And I can say they earn it. The work is, they're definitely doing the work. Irrevocable trust. An irrevocable trust is just what it sounds like. It's not revocable. Once you form this trust, in general, it's not revocable. It is very hard to break an irrevocable trust. And one of the main reasons folks do an irrevocable trust is to protect their assets. Protecting the assets from Medicaid is one of the biggest reasons. It's also a protection of assets from litigation, from creditors, because you truly don't own this money anymore. It's been transferred to an entity that in general is not revocable. You also cannot be the trustee. Because you can't say on one hand, it's not my money, you can't sue me and take it, I don't own it, but you're still managing and controlling it. So you can't have it both ways. Let's talk about one of the biggest benefits of the irrevocable trust is Medicaid planning. In New York, everybody's probably heard of the 5-year look back. Mm-hmm. So I'll briefly, does anybody not know what that means? Okay, so if you go into a nursing home, in order for Medicaid to pay for your care in the nursing home, the Medicaid wants to confirm that you meet certain income and asset guidelines. So your income can't be over a certain level, and you can't have more than, it's give or take around $14,000 in financial assets, right? And they do an asset test, and they look back. This is where the look back comes from. This is, remember, if you're going into a nursing home, they will ask you for documentation for the last 5 years of any property that you've owned and or sold, and they want all of your bank statements for the last 5 years. And if you say, I don't have that, they say, well, go to the bank and get it. The bank will give it to you. And they really do comb through to see what your assets have looked like for the last 5 years. If you have transferred out any significant amount of money in the last 5 years, they will deem that your first spend down. So if you tried to get nifty and you had a couple $100,000 and you transferred it out and gave it to your brother, they'll say, okay, we will pay for your care here in this nursing home after you pay for the first $200,000 worth of your care. Or go back to your brother and get the money, right? That's that 5-year look back. So, that's for what we call institutional Medicaid. Under New York really has one of the best Medicaid programs in this country. I don't work for Medicaid, I have nothing to do with Medicaid, but it really is phenomenal. When people want to move to this place or that place, like, okay, don't get sick in this place or that place, right? So what New York also has, which is their really, I like the word nifty, their really nifty plan is community Medicaid. Community Medicaid means you're going to stay in the community. You're going to live in your home, you're going to live in a family member's home, you're going to live in the community in a private residence. Right now, in New York State, there's no look back period. Meaning, if we take all of your assets and put them into an irrevocable trust, and you cannot be the trustee, we take all of those assets and put them in the trust today. Tomorrow, we can apply for community Medicaid for you, which means you'll be at home. Unfortunately, if you're sick or incapacitated, and the aides and all the good folks will come in and look after you. They may have to come in for an hour a day. New York, they can come in for as long as 24 hours a day. I know this part personally, we did this for my mom, right? She had 24-hour care at home for about 5 years. It was a long time. It drove my father absolutely nutty. He couldn't take it. All these folks in and out of his house, but we also didn't want her to go into a nursing home. He didn't want that either, but he didn't realize his home was going to be turned into like a little mini nursing home. So it was a bit of a balance there, managing all that. But so New York back in, I think it was 2020, the powers that be passed legislation approving, I think it's like a 2.5-year look back for community Medicaid, right? But they haven't implemented it yet. Every year they keep saying, this is the year we're going to implement it. This is the year we're going to implement it. Back when I was doing these kinds of talks and talking with clients, I'd say, hurry up, put your stuff in an irrevocable trust and let's hurry up and do it because they're going to implement it soon. Now here we are almost 6 years later. I don't say that anymore because I don't want people to think I'm rushing them to do this when this was passed like almost 6 years ago and they're not doing it. Back in 2020, 2021, there was a sense of urgency. I don't know. We all know it's going to happen soon. There's some nooks and crannies that they're sorting out. It just hasn't happened. So the other thing about an irrevocable trust, similar to a revocable trust, is that they're private. Like that will gets filed in court and it becomes a public document, right? It becomes public information also for creditors. It's amazing. I still don't understand the whole database. The second a will is filed, all of the creditors start filing creditor liens against the estate. Oh yeah, it happens like lickety-split, right? With an irrevocable trust and a revocable trust, it doesn't get filed anywhere. Nobody knows anything, right? You also, in case you're concerned, and we all should be, about estate tax, it reduces your estate tax because you don't own it. Let's say you're worth $10 million. If you die and you have a will, that's a lot of estate tax that your estate will have to pay. But if you put all of these assets into an irrevocable trust, not a revocable trust, an irrevocable trust, you don't own that $10 million anymore. So now when you die, there's no estate to tax, right? The reason it's different for a revocable trust is, remember, it's still considered your money because you can still do whatever you want with it. You're the trustee. Even if you're not the trustee, you can still revoke it and terminate it. So it's still actually yours. There's creditor protection and there's liability protection. Creditors can't sue an irrevocable trust because it's not your money. Same thing with a lawsuit. I can't sue your irrevocable trust to try to get money because you don't own it. It's just not yours. We'll talk, if anyone wants to, for a second after this about special needs. Special needs trust, if there's folks who themselves get disability or their children are receiving disability, there's ways to put money into what's called a special needs trust so that, let's say I put $100,000 into a special needs trust for someone who's receiving disability because they are fully disabled. Typically that would, if I just gave them that money and they put it into a bank account, that would negate their benefits that they're getting. But if I put it into a special needs trust, it doesn't. So that doesn't mean that they get to access that money whenever they want. They cannot be the trustee of that. Someone else is the trustee. And the full term is called a supplemental special needs trust. So sometimes someone may be disabled and they're getting $1,500 a month, right? Barely enough to live on. And they live in some special housing situation where their rent is subsidized. All of their expenses may total $2,000 a month, right? But they're only getting $1,500 a month. So the trustee of that special needs trust can pay $500 a month toward the extra expenses that they have that they can't cover for themselves. So that's kind of the big issue with the special needs trust. Now remember, with the irrevocable trust, let me see if I've skipped anything. I'm sorry, let me go back. For Medicaid planning purposes, and we do it, we recommend it, I'll say, for people. It's a balancing test, right? Because you don't know if you're going to ever need Medicaid benefits, right? New York, I keep saying New York has phenomenal Medicaid, and if you ever worked, ever, even, when you were 18 and you worked at McDonald's, they were taking out money for Medicaid. So it's this long-term health insurance policy that we've all been paying into for a really long time. And now it's our opportunity to withdraw from it if we're ever ill and we need those kinds of benefits. And New York State, in its great wisdom, has created this vehicle, this irrevocable trust. It's not illegal, it's not a secret. People might think, what? You get to just take all your money and put it away, and that makes you Medicaid eligible? Yes, it does. And it makes modest means people Medicaid eligible. It makes phenomenally wealthy people Medicaid eligible. And it's done every single day, all day long, and it's perfectly legal, it's perfectly acceptable, understandable, and it's perfectly something we should all consider. When do you do it? That's the big question. When do you do it? If you know that you have a debilitating illness, some of these things progress quickly and some of them don't. I have a friend that has MS, right? She was diagnosed, I'm almost 60, she was diagnosed like 40, like 20 years ago. And she's kind of okay, right? Things like MS, she could have been in a wheelchair by the time she was 41. Now she's getting to a place where it's really starting to change her life, I'll say that. But who knows how that was going to turn out 20 years ago, right? And other kinds of illnesses, you have a little bit more of a time frame, like, I'm going to need a lot of care that I can't facilitate on my own. Maybe it's time to do that irrevocable trust. Or some people just do it by age. I'm not going to say what age to do it. Some people say, I think, and people ask me all the time, what age do I do it? There are some, I'm going to be 60 in a few months. There's some 60-year-olds who do it. There's some 80-year-olds who say, nope, I'm not quite ready. I'm going to do it later. And right now, because there is no look back for the community Medicaid, you can keep pushing the envelope a little bit. They will announce when they're going to start implementing it. It's not like we're going to find out on the Friday 6 o'clock news that it's going to start on Monday. There'll be some sort of window. But then there's the issue of the institutional Medicaid. If any of us think we might end up going into a nursing home, that's a 5-year look back. That's another kind of math. Like, and that I can't give advice on because it's not appropriate to say, well, you're such and such age. In 5 years, you think you're still going to be, rocking and rolling, or you think you might end up in a nursing home. It's something that you have to kind of, I think, talk about amongst yourselves, talk about with family members, and decide. Because there's a big decision with the irrevocable trust. You cannot be the trustee. I can't say that enough. So if I decide to do an irrevocable trust, you are now my trustee. I have no more dominion and control over anything. Oh, let me step back. For both the revocable trust and the irrevocable trust, if you have those, what do you call those things on your house where you have the star exemption, the senior exemption, there might be one for veterans, all those still apply. That just because you took the house out of your name and put it into a trust, all of those exemptions still apply. That's really important for people. So in this example, I'm doing the irrevocable trust, and you are now my trustee. I don't get to decide anything. Now, if you are my trusted friend, or my son, or my brother, then really what's happening in real time is we're talking and you know what my wishes are and what is in my best interest. But day to day, I'm not writing out the checks to pay my Con Ed bill or to pay my TJ Maxx credit card bill. I'm not, remember that? I like TJ Maxx. I'm not, I'm not in charge anymore. I can keep that $14,000 a month. I'm sorry. I can keep that maximum $14,000 in my bank account. Hi, good morning, good afternoon. And then there's an income guideline that we'll talk about in a second. But that's it. You have all of my money and my house as trustee. That's a big deal for people. That's a really big deal. I'll say for our people. That's a really big deal to take everything we've worked for and earned, including our house. That's often everybody's biggest asset, and it's not in our name anymore, and we can't control it. Yes, ma'am?
It's no longer in your name. Who pay your bills?
You're a trustee. Yes, it's now in the name that's generally on the deed and all the bank accounts and stocks and mutual funds is the Sonia Tanksley Irrevocable Trust. And it has its own tax ID number, and this kind man is my trustee. So he may come over, twice a month and sit and do the bills with me so that I'm still aware of what's happening and making sure that all the bills are getting paid the way I want them to be paid. I don't care that it's due on the 15th. Can you please pay the bill on the 1st like I asked you? He can be nice and try to, do it for me, but he's in charge. He may not pay it till the 15th when it's due. If you're my good brother, you'll do as I ask you to, but you don't have to. You could be my bad brother.
So he can just sell your house if he wants to.
Pardon?
He can just sell your house?
No. Well, I mean, there's, by the letter of the law, yeah.
Yes, because I know some.
There are, yes, they sometimes run amok, right? So you choose wisely. Sometimes, again, people choose two trustees that have to act in concert. So then he'd have to get in cahoots with you in order to do something that he knows I would not have wanted and may not be in my best interest. There's other legal things that can be put in place as a protection for that. So, for example, that deed can be owned by the Sonia Tanksley Irrevocable Trust, but Sonia Tanksley has a life estate, meaning I get to live in that house until I die. So he may sell the house to you, but guess what? You now own a house that I get to live in until I die. So who wants that? And to break a life estate, you got to go to court and get the court's approval to say she no longer has the right to live there for the rest of her life. It's not easy to break what we call a life estate in a house, because that's why people do it, right? I put the house in an irrevocable trust, but I have a life estate. I get to live there. You know, generally life estate means I'm also paying the general maintenance for the house. I'm paying the utilities and, you know, the day-to-day upkeep. But be careful about buying that house from him as he's trying to do me bad, because I'm going to be living there and I'm going to make a mess. Because I'm bad. Maybe not a mess, but I'm not going to be a good tenant for you. So, yes.
Can a property have a lien on it and be placed in irrevocable trust?
Say that again, please.
Can a property with a lien on it and be placed in irrevocable
So that's a very good question. These are some of the granular things that I don't always talk about, but if the property has a lien on it, like a mortgage, then you have to ask the lender if the house can be transferred to an irrevocable trust. Most lenders say yes. One lender that I know always says no is Banco Popular. They're like, nope, we're not doing it. They're just, and well, there's a reason they don't do it. I think the bank originated in Puerto Rico, and although Puerto Rico is a U.S. territory, it's Puerto Rico has their own intestacy laws that are different from the rest of the United States. So the irrevocable trust, it conflicts with some of their intestacy laws. So rather than make life complicated for themselves, Banco Popular just says no, we're not going to allow you to transfer it to a trust. But most banks say yes. You give them, and this is the tricky part, you have to give them the executed trust. So you will have, and remember I like to talk the real side of this, you will have paid the attorney to prepare the trust and do all the work, right? You may have even transferred your financial assets into the trust, and you know it's not inexpensive. It's a fee, not to transfer the assets, but to pay the legal fees. And then the bank may say no. There's this one other bank, I can't think of it right now. But you know what? The other benefit still is that your financial assets are protected. The issue is sometimes, depending on the person, sometimes our biggest financial asset is our house, and that's what we were really trying to protect. And you know, some of the banks, like for me, I keep a little list of the banks that have said no in the past. So I'll look at my list and I'll say, you know, we can try. And they're so, sometimes they're annoying, because even if you just call and get someone on the phone and try to go through a conversation, and they'll say, nope, send us the fully executed trust and we'll let you know. It's like, well, by that time the client has spent a bunch of money. So it depends on what your financial portfolio is, honestly. If your house is your biggest asset, and that's really what you're trying to protect, you know, it's something to consider. But if you also have financial assets that you want to protect, then it still could be worth it. Yes, wait, let me write down one thing before I forget, and I just forgot it again when I said that. Oh, darn it. Hold on, nobody say anything for 1 second. It wasn't about the lien. It'll come back. Go ahead.
Is it safe to say a living will can support a irrevocable trust? Can it go hand in hand?
So, you know what? That's on the next page. Depending on how your thing is paginated, because I have notes here. You see where it says pour over will? Does yours have pour over will?
Yeah.
Have you come to one of these with me before?
No.
Oh, okay. So we can talk about that.
To what you're saying.
Okay.
I know I'm a legal, so
Okay, yes. So whenever we do a trust, whether it's a revocable trust or an irrevocable trust, we always do something called a pour-over will. And a pour-over will is to capture any assets that you don't put in the trust at the time that you're preparing the trust. Or there's some reasons why sometimes you may not do that asset at the time. And for any assets that you acquire later that you may decide not to put into the trust, or heaven forbid you pass away before you have an opportunity to put it into the trust. So the pour over will be a lot less specific than the regular will that you may have if you don't have a trust. And the pour over will say all of your assets go to the ABC trust. The beneficiary of that pour over will be the trust. Or you name an individual as the beneficiary of that pour over will. And the reason is because, and this is when we get into some of the legal granular stuff, is once you make the trust the beneficiary of that pour over will, now when you go probate that will, the court also wants you to give them the trust. So now that trust that was going to be private is no longer so private, because you have to give it to the court so they can read it in concert with the will. So, I always kind of do the balancing test with my clients. Sometimes the trust, the privacy of it isn't so important. And it depends on who you are. It depends on your assets. It depends on the liability exposure you may have, or the creditor exposure you may have. If you don't really have any of that, then it may not be an issue to have to file that trust with the court. But for some people, one of the reasons they're doing, particularly this irrevocable trust, is they want it to remain quiet, and not just quiet, but private. So in order to keep it private, you would name a beneficiary or two of that pour over will, which means that will would have to be probated if there's any significant assets that need to be probated. If there's not, then there's a decision of whether even to probate that pour over will. Because if the pour over will says my quilt is to go to my granddaughter, my earrings that my mom gave me are to go to my daughter-in-law, do we have to probate that will? We can talk about that when we're not being recorded.
One last one.
Go ahead.
So I have a girlfriend and her father died, right?
Uh-huh.
And during the whole ordeal, before he passed, he has a house in his name. So he was from the hospital to the nursing home he went. And there was some kind of stipulation or some kind of contract with the house where if he passed, because I don't know if it was he didn't have a will or he didn't have the money but is that something that could happen?
You didn't finish the sentence. There was some sort of contract that
the house was like the asset. The house, if he can't pay the bills and so forth, I guess they get the money from the house or get some kind of, I don't know. I know that the house, huh?
The nursing home.
Gets the home.
Oh. So the nursing home may have had a lien on the house.
A lien.
Yeah, the nursing home, he may have allowed the nursing home to put a lien on the house.
Because you didn't have a trust, right?
It's not a trust, yeah. And he may have been doing self-pay at the nursing home.
That's why I didn't know how to ask the question, because I was wondering what the house has to do with the nursing home.
And he may have been doing self-pay at the nursing home. These are, I don't know, but these are some options I'm thinking of. He may have been doing self-pay, and let's say the bill for the nursing home was $5,000 a month, but he only had, it's much more than that. The bill at the nursing home is more like $10,000-11,000 a month, and maybe he only had $7,000 that he had available to pay. So they said, okay, we'll lien your house for the other $3,000 a month that's accumulating.
Yeah, that's what it is. Okay.
That
could be it.
That could be it. Yeah. So then if there's no mortgage on the house, then the nursing home will have first dibs at that house. Yeah. Which is a way to keep him, cared for.
That's right.
It's not so bad. And sometimes I say to people, don't feel so bad because your loved one's assets went to pay for them. You have no, and this is tough for people to hear. your parents' money is not yours.
Yeah.
It's- and people get very, very upset with that, but it's like you have no legal right to their money. Yeah, so if they go and they spend it all on themselves and their hair and their whatever, or if they ride down the street just tossing it out the window,
That's their business.
it's their money. Yeah, and if they, I've had to try to quiet conference rooms down sometimes when kids are fighting because more money was given to this one than to that one. And the thing I say, which is very shocking sometimes, is it's their money. It's whatever reason they gave Johnny more than Jenny, that was for them to decide, and just maybe be grateful at the $2 million that you got versus the $4 million that he got. So, but people don't like to hear that. Yes.
Can you put a business in a irrevocable trust?
Can you put a business into an irrevocable trust? So what we typically will do is we put that business into an entity, let's say just an LLC, and then the LLC goes into the trust. So the answer is yes. There's some other processes that have to be incorporated, but yes.
And the irrevocable trusts, are they just good for individuals, or can churches do the same thing?
Meaning, finish that. Like, can churches do what specifically?
I don't know if you have, say the church have this property and they want to put it in a irrevocable trust. I mean, is that a good idea?
Well, it's different for a church because a church is a nonprofit and a person doesn't own a trust. Doesn't own a church. No one owns the church, right? So I have to think about that. Churches are actually even different from other nonprofits. That's a good question. Why would you want to do that? Tell me why.
We have a church.
Sometimes I can back into the answer by understanding what we're trying to
We don't have to pay the taxes. We don't have to pay the taxes, right?
Right, because the irrevocable trust, one of the main purposes is being able to pass on those assets and avoid liability, so nobody can sue and try to get those assets. Let's say me, I have $10 million, but I've got all these things I've done, and these businesses want to sue me because I didn't pay them when they did work for me, because I did a transaction with them and I defaulted on the contract under the transaction. All of these things, right? So I don't want these people coming after my millions of dollars. So I put all my millions of dollars into this irrevocable trust. Now I don't have any money. Good luck suing me, right? One of the other reasons we do it is to make ourselves Medicaid eligible. Medicaid income. That's it.
Came back to you.
Yep. I want to talk about the income eligibility. So one of the other reasons I did the irrevocable trust was to make myself eligible for Medicaid. So I put all of my assets into the irrevocable trust. So tell me why the church would be put into an irrevocable trust, and whose irrevocable trust is it being put into? And why?
Say the church builds some apartment buildings or something.
Okay.
And you want that remains a part of the church forever, so that no trustees at any point in the future can say, okay, or anybody in any point in the future can say, okay, the church owes money, we can take this, or we can sell this. You want whatever the church has to stay the church's forever.
I understand what you're trying to get at. I do. That there's this trust that acts as this umbrella, so that, and there's 1, 2, 3 trustees of the trust that carry on the church and the business of the church, which is the apartment buildings, the real estate, without interruption. That's not there are certain trusts that can facilitate that, but that's not an irrevocable trust. But there are certain kinds of trusts that, and it wouldn't be the church itself, it would be the church's, maybe the church's properties that could be in a trust.
Okay, but it just wouldn't be an irrevocable trust.
I don't think, I have to give that some more thought and look at a couple of trusts that I'm thinking of to see if that's permissible, that nonprofit put its assets. I think the big answer is yes. The smaller answer is making sure it's done properly so that we didn't go against the nonprofit status. Because you never want to interrupt that and end up having to pay all the taxes. Yes. Oh, I thought your hand was up. No. Oh, income. So, yeah, it's cold. But there's a little heat thing right here that I'm standing
Just so
by.
that you know, I came here before 9 this morning and turned off the heat. But here is the thing. The cold outside is stronger than the heat inside. That's why you're experiencing the cold inside. Okay? All the floor stuff they're on and on to the maximum. And we need to remember to turn them off when we're done. It could have been freezing cold if they weren't on. So sorry about that.
So there's another aspect that, just to keep this in the back of your mind, I don't want to make this too complicated, but Medicaid eligibility, we're going back to that irrevocable trust, which is one of the reasons we do an irrevocable trust. There's the income eligibility, which is why we're putting our assets, there's the asset eligibility, which is why we're putting our assets into that irrevocable trust. And Medicaid also has an income eligibility, meaning you can't earn more than, it's not a lot, let's just say $2,000 a month, right? It's lower than that, but I'm gonna just use a round number. If at the time you apply for Medicaid, and you have your assets in this irrevocable trust, right? So all you have left is your $14,000. So you meet the asset test. But you have $10,000 a month in income between your investment income, between your pension, between your Social Security. You just have $10,000 a month income. And let's say for our example, $2,000 a month is the maximum that you can have. We're talking about income. Right? Because we put our assets away. We're poor on the books in terms of assets. We do something called, and this is where I don't want you to get confused. We do something called a community pooled trust for that excess income. So the maximum income was $2,000. You earn $10,000 a month. Right? So that other $8,000 a month goes to a community pooled trust. And a community pooled trust, the best way to explain it, and this is only after you've applied and been approved for Medicaid. You don't do this before, right? Think of them as like little mini banks in New York State that have been approved and vetted and qualified. And they act as a trustee of that $8,000 a month income. Everybody remember where that $8,000 is coming from, right? And so what happens is they take that $8,000 every month. What you want to happen, and what does happen is they'll pay your bills out of that $8,000 a month. So if you have a mortgage, they'll pay your mortgage. If you have a car payment, they'll pay your car payment. You can't have like a Bentley, but because Medicaid is, Medicaid will look at that as a significant asset. Like, wait a minute, maybe you should sell that Bentley and pay for your care yourself. They'll pay, they can pay your medical co-pays. If you're buying your groceries every month on your credit card, they can pay your credit card bill. They can pay your TJ Maxx credit card bill. I don't like TJ Maxx. They can pay if once a year you go on vacation. You're allowed to go on vacation when you're receiving, Medicaid, and it doesn't mean you have to just stay at home. They can pay that credit card bill for your vacation and things like that. So they can spend down that extra $8,000 a month. It's not extra because it's your money, but they spend down that $8,000 a month. But the thing to keep in mind is when you go on and you pass on, whatever you didn't spend down a month from that pooled trust goes to Medicaid. So if you don't have an extra $8,000 a month worth of expenses, it goes to Medicaid when you pass on. They just keep it, and it keeps growing and growing and growing, right? And you can't just say, oh, well, I'm gonna go on a worldwide trip that's gonna cost, let's say over a few months, you've accumulated $32,000 in your account. You can't just say, oh, I'm going on this worldwide trip and it's gonna cost $30,000. That's not gonna work. It can pay for renovations, real renovations in your house. Like let's say you have to renovate your bathroom, both bathrooms to make it wheelchair accessible. But don't renovate your friend's bathroom and give the contractor bills to your trustee. They're stewards of this money and they have to do their own reporting and they're fiduciaries, right? They're not gonna lose their shirt over you. So that's something to keep in mind because there's two prongs to that Medicaid eligibility once you put your assets into that irrevocable trust. There's the asset, which you will have passed because you put all your money into that into that irrevocable trust,
So you don't have any money then?
You don't have any money.
Yeah.
Exactly.
So the
But then you still have your income.
So you have your income.
You do the community pool trust.
You do the community pool trust. But just remember that whatever you're not spending every month in bills, they keep it. And in most instances, I can't tell people what to do and how to value their money, but in most instances, it's still worth it, depending on how the numbers bear out. So, depending on the level of illness, you have to look at a lot of factors. Because if you can stay home, because that's what we're talking about mostly here, right? This community Medicaid where you're going to stay home and have folks come in and look after you. That's less expensive than nursing home care, right? And you've protected your assets from liability, from creditors, right? And you're either going to spend that $8,000 plus probably a month in home care attendance, privately paying them, right? Or you're going to give it to that pooled trustee and they'll pay some of your bills, right? Whatever your bills are up to the tune of that $8,000. Plus you'll get your care. So I don't want to get too much into the social work side of it, but it's different for every person, and you really have to sit and I have a Medicaid consultant that when we get to this point in the process with clients, I have the Medicaid consultant. Well, I try to bring in the Medicaid consultant. It's up to the client to retain them and have them sit and chart through what this will all look like and what's the best road for them. But I think it's, without just spending folks' money, I think it's worth the investment if you're at that place in your life where you really have to think about what you want your care to look like. It's worth investing in the professionals who are only there to guide you, and this is all that they do, right? They just do Medicaid consulting for people all over the place, all the time. Because they know what it looks like, they know what home care costs, they have the relationships with the different home care agencies, so they know what it costs out of pocket. They know what the home care services look like when Medicaid covers it, and all those kinds of things. So we did that. I wanted to get back to that income. I don't know what you just said to remind me, but I remembered. the benefits and the downsides to the irrevocable trust. You cannot terminate it without the consent of the beneficiaries. That's the irrevocable trust. So, with the revocable trust, it's still your money. You just have it in the trust. You're the trustee. You're doing everything you want. With the irrevocable trust, you've taken it out of your name. You put it in the trust, and you no longer control it. And this kind gentleman is your trustee. In order to terminate the trust, it's a really big deal. And whoever you've named as the beneficiary or beneficiaries, it's not their money yet, but it's as good as their money. Wow. Because when you die, they're getting it, right? I know I just said it's not your money and that's your parents' money, but with an irrevocable trust, you've taken it out of your name and you put it in this vehicle. And no matter what, you're going to get the money when I die. One thing's for sure is I'm going to die. I don't know when, but I'm going to die and you're getting this money. So if I'm going to change all of that, you have to agree. That's what the court says. So I've got to get your consent to terminate this irrevocable trust. And beneficiaries never want to consent. They take it as, this is my money, you can't take it away from me now. Go ahead, ma'am.
Why would you want to establish an irrevocable trust at this point? Just based on what you've just said.
Because you're still getting the benefit of making yourself, for the most part, one of the biggest reasons, if we're not talking about liability or, from lawsuits or issues with creditors, the biggest reason is because you are making yourself Medicaid eligible in the event you either, in 5+ years from now, go into a nursing home, and just like somebody over there's a lien on that person's house, right? Or you're going to stay at home and receive the, home care at home that you don't have to pay anything for. And there's a lot of other bells and whistles that home care Medicaid gives folks. It's not just allowing the aides to come in. You get all these other little trinkets, like you go to the what do you call that place? You go to the pharmacy, and there's this whole list of things that you just get for free. It's incredible. Anyway.
I asked that question because I am over 50.
Me too.
So I'm thinking of my child. I have a child and he has children. So I would like to, I'm thinking that maybe it's time for me to do a trust.
Mm-hmm.
Okay. But based on what I'm hearing here, it would appear that I would want to do a revocable trust.
And sometimes people decide, right now I'll do a revocable trust. And I'll continue thinking, evaluating, researching when and if I want to do that irrevocable trust. Because there's no turning back, basically. Yes?
What if you do an irrevocable trust and one of your beneficiary dies before you do it?
Well, remember, if I do your irrevocable trust, you're going to have at least one or two alternate beneficiaries. So, if of course they could all pass away, but the likelihood of that is small, right? That you name 3 people as beneficiaries and they all pass away.
But if maybe one passed away and I want to do something, I want to change. Can I make a change then, and it's easier for me to do the change if one has passed?
It's not easy.
It's not easy.
Yeah, that's why you name several people
Okay.
as beneficiaries, because it's not easy to change that trust.
So is it better to start with a revocable one and then later on?
Well, it's not necessarily better. It depends on where you are in life with respect to sometimes age, sometimes health conditions,
So
right?
So let's say you're just in your 50s and you're healthy, or your 40s and you're healthy. You could start with a revocable one and then maybe as maybe in his 60s and 70s.
As condition changes.
And it depends, it also
change.
depends on your
Yeah.
financial status, because sometimes, depending on your financial status, you will put a significant amount of your assets into that irrevocable trust now.
Excuse me. Your answer is okay, but I'm thinking, except you consult with God. 'Cause
Pardon,
you
say
know
that
when
again?
except you consult with God, because you know when you die anyway.
We don't know.
It's a gamble that you play. Because you can prepare the document, and then tomorrow you up there about doing your process. So everything you do is to pray to God and say, when I want to die.
Well, what we're talking about is knowing that we're going to die, right? And God has not told us when. And preparing assets to go to the people that we want, as opposed to having New York State decide where they're going, right? And then this other part that we're talking about in the last couple of minutes is, to the extent we can, making preparations for the ability to preserve our assets for the people that we want to have them. And in doing that, allowing this Medicaid insurance plan that we've been paying into, that we can draw on it. Because there's a little bit of, most insurance plans that we pay into, we can draw from it. There's no, there's no anything. With Medicaid, although we've been paying into it, it's, there's income and asset guidelines in order to draw from it. Oh, I'm sorry, I sat, you had it, sorry. Okay, so that's what we're talking about, to see if we can preserve these assets and allow them to still go to who we want. Because what happens is, if we don't do what we're talking about in this last couple of minutes, this Medicaid planning with respect to the irrevocable trust, and we find ourselves in a place where we have to go into a nursing home, or we have to get care at home. We won't be eligible for Medicaid. And that's not the end of the world. That just means that we have to figure out a way to pay for our care ourselves. Or, so we'll spend down our own assets. That's not the end of the world. Or if we're in a nursing home, the nursing home simply puts a lien on our assets, on our fixed assets like real estate, and we just have to pay out all of our cash to pay for ourselves. That's not terrible. We worked for it, it's ours, we're spending our money to take care of ourselves. We talk about these kinds of vehicles that we can take advantage of if it's our desire to have them passed on to people that we care about, we love, or we want to donate them to organizations like the church or another kind of organization. Lots of organizations do good for the community. So if that's our desire, to have our assets go as we want them to go, to other places as opposed to just paying for our care, then we do that. And then sometimes, we just die. We don't have to have long-term care. That happens too. But it would still be nice for some of us, we think, to be able to dictate where these assets go, as opposed to New York State deciding. If you're married, it goes to your wife and some to your children. If you're not married and don't have children, then first it goes to siblings. Then if you have no siblings, if your siblings have all passed on, it goes down to their children. If you never had siblings and therefore there's no nieces or nephews, it goes back up to aunts and uncles if your parents have already passed on. If there's no aunts and uncles, they've already passed on, then it goes back down to cousins, and so on and so on. And that's what I mean by New York State deciding who's going to get your asset.
What if you owe the IRS?
If you owe the IRS, so if you pass on and you owe the IRS, there's all these creditors that have first lien position. The IRS always comes in first. They come in high. Yeah, and so, but if you've transferred all of your assets out as we're talking, into an irrevocable trust, you don't own anything, they can't get them.
Okay.
I have a question.
Oh, yes.
We're going back to the trust.
Mm-hmm.
Are there legal fees for the trust, or it's just who prepares the trust, like a lawyer?
Right, there's no ongoing legal fees to manage the trust, and like I said, the trustee does get a statutory commission.
Mm-hmm.
But there's no management fees of the trust, because remember, it's just that this entity now owns your assets, like owns the house. So you're still paying your property taxes and the maintenance for your house. Your bank account, it's still the regular bank fees related to your bank account.
Okay, but you have to pay someone to prepare the trust, right?
You have to pay, yes, typically you pay an attorney to
You
prepare the trust.
you pay an attorney, and once you pay the attorney, that's over.
That's it, that attorney doesn't stay in relationship with you throughout the
What's
process.
typical cost?
Pardon?
What's typical cost of our irrevocable trust?
It depends. It depends on, and it really does depend based on, what you're doing, what the complexity of the trust, because I've just been talking about basic trust today.
Let's just ask for a basic trust.
I can't answer that. It really depends. Call me and tell me a little bit some personal things about what you're trying to do,
Okay,
and then I can give you a better range.
alright.
Yes.
I want to ask you a question that doesn't have anything to do with this.
Okay.
Some years ago, there was a man in Jersey, had a job, like him, married. Something happened between he and his wife, so they wanted to go in divorce, but it stayed within 2 years going through it. At the same time, he had a girlfriend. The girlfriend had been with him for 2 years.
So he has a wife and a girlfriend?
No. He has a wife. Something happened.
Okay.
They separated.
Okay.
They were in the process of divorce.
They weren't divorced yet.
But they have been for maybe 10, 15 years.
But they were still legally married.
Yes.
And this is in New Jersey.
Yes.
Okay.
He has a girlfriend who has spent over a year with him.
1 year.
1 year.
Okay.
But one day he wanted to play the lotto ticket.
Oh.
He won $5 million.
Okay.
So they called him to go pick up a check. But what he did was he carried his wife and a girlfriend. This is no joke. This is for everything else. So
He brought them both with him?
yeah.
Okay.
My question is, what benefit this girlfriend has to that money?
Nothing.
She is not entitled to anything.
She's not doing it.
She's not, New Jersey is, well, I mean, even if New Jersey was a common law state, he's still legally married. So you can't have, that's it, once he's still legally married.
The woman your wife changed your mind automatically prior to going to the lottery ticket.
She changed her mind about being separated.
What if the
Okay, it's getting a little late, so let's try to get through the last part. The last part I just wanted to talk about was adult guardianship, because often we find ourselves in situations where our loved ones, whether it's an adult child, an adult sibling, or a parent, really cannot look after themselves at all. So a power of attorney doesn't do it. A healthcare proxy doesn't do the trick, right? Because they are in a state due to their physical and often mental health status where they really need somebody to step in and just take over in their life. So in those instances, we look toward guardianship. Now, once you're someone's guardian, it's in the layperson's way of thinking about it, it's as if they're your child.
Yeah.
You are really fully, completely responsible for them. And we probably all know somebody, whether we know them personally or we've heard of these situations where a person really just needs someone to step in and just take control and look after their best interests. And that may be changing their residence to put them in a group residence situation, or put them in a nursing home, or have them come live with us, or something, because it's just not safe for them to be out navigating the world on their own anymore. So there are vehicles in which you can, a vehicle in which you can petition a court to have someone appointed to manage a person's personal and financial needs. In those instances, we call that person an incapacitated person. The person that's appointed to handle those affairs is called their guardian. You can be the guardian over a person, and you can be a guardian over their assets. You don't have to be the guardian over both. Sometimes the court appoints two different people for both of those responsibilities. Sometimes it's the same person, and sometimes it's just not. I recently did a guardianship proceeding where initially it was the person, where's he from? I think Grenada, and the best buddies in Grenada. My client is here, and the person we call the person the IP is also here. My client's married, and they stayed best friends with their best buddy, but best buddy really could not navigate the world anymore. So my client wanted to be the guardian. And in his mind, he thought, yeah, I'll just handle everything. The best buddy who needed looking after had a house and some financial assets, some pretty significant assets. But as he went along in the process, he realized, I just want to make sure he's okay. I can't deal with his house and his money. So the court appointed somebody else to be the guardian of the assets. And my client gets to be the guardian of the person. And the intent is to take him back to Grenada for a few months in the year to visit with their old family and friends. So it's a wonderful scenario, and somebody else who's more equipped to handle with the financial portfolio is handling all of that. The guardianship proceeding. The guardianship proceeding is just that. It's a court proceeding. Petitions are filed in court. There is someone that's called a court evaluator that will be appointed. The court evaluator is the court's, it's really the court's eyes and ears who will step in and evaluate the entire situation to make sure that this person actually needs a guardian. Because just because I say I need to be the guardian of my brother, who knows what's really going on there. So the court evaluator steps in to really look out for the best interests of my brother in that instance, and make sure I'm not just trying to step in and manipulate my brother. And then the court also asks for the other family member participation. So if I'm petitioning the court to be the guardian of my brother, the court's going to want to see affidavits and possibly testimony from my other two brothers, from my brother's children, from really just from the immediate family, because the court does look at it as, it's not in family court, it's done in Supreme Court, but the court does see it as a family matter, and they want to make sure that all of the issues, to the extent related to the incapacitated person, are being addressed. There is ongoing court supervision, specifically by someone called a court examiner, and that court examiner will make sure that me, the guardian of the person, and if there's a separate guardian of the assets, to make sure we're doing what we're supposed to be doing. That, they will go out and they'll visit the incapacitated person to make sure they're not living in squalor. The person who's the guardian of the assets has to file annual financial reports saying what money was taken in and how the money was spent, like with real specificity. You really, they take it very seriously. You're not allowed to just step into this role and then just not do the right thing by this person that the court has deemed incapable of managing themselves or their assets. Any questions?
Good.
Yeah, thank you. I hope you enjoyed it. I hope you learned some things.
Here is the thing. You have her card.
Oh, you have a question? Oh, it's here. I'll leave it right here.
Yeah. So you have access to a card, which means you call her and you build out that relationship so that you can have satisfied the deep-seated desires that you have. So I want to express gratitude to you. Your willingness to come and do this, and your willingness to come and do this in this kind of cold as well. And so I'm happy though that all of us came out. Initially we thought we were going to be just two.
Yes.
But all of
The
you came
faithful
out.
few.
Yeah. So the hope is that we'll keep these kinds of experiences available so that we can follow up with similar experiences, and we'll consult with you as a church would to see how we can continue to have
Absolutely.
seminars, workshops like this.
Yeah,
So,
I have other friends and colleagues that can talk about other topics as well.
Okay.
You know, even things like what to do at a. Hopefully, we don't have these interactions, but in the times we live in, what to do to keep yourself safe at a police stop. What are the things that you can say? What and to answer. And,
Well, at this time primarily,
yeah.
it's ice.
Yes. Well, yes.
It's ice.
And and to have people come and talk with those lines too. Yeah, there's lots of things to be armed with for information.
But we are thankful that you came. Let us again show our appreciation for.
Thank you for having me.
Also, I understand that there are some refreshments outside.
Oh, that's fantastic.
Here is the thing. Somebody said we must bless the food. So let's just do that, and then we can go and partake of. And we thank the hospitality committee ministry for advancing this cause, so that afterwards we could refresh ourselves. Thank you, Lord, for the food that has been prepared and made available to us. Thank you for the hands which prepared it, those who provided it. We pray, oh God, that you'll keep us mindful of those who have no meal so that we never waste, always seeking to advance self-sufficiency. Into your hands we commend all things, including the food. Amen.
Thank you, Lord.
Yeah, man. Yeah.